Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
There are still some lights that are there, even when I change it to medium. Right. Okay, yep, there are still some lights around, so if you want to be under a light, then just move to a seat under a light. Okay, so let us keep going with deductions, right? So it's a really important topic. You'll definitely need this knowledge for the final exam. So what we did last week was we looked at Division 8, we looked at the general rule of deductibility, we looked at the positive limbs, and we also looked at what we call the negative limbs. So to recap, right, because it's always important that we understand the big picture in terms of the framework, the framework for income tax law and the framework and structure for the major topics. So if we go back to last week, what are the positive limbs? Right? This is a bit of legal jargon to talk about positive limbs, but actually they are very important in terms of knowing when an expense outgoing loss is deductible. So can I have a volunteer, please? What do we mean by the positive limbs of Division 8 of the 97 Act? The positive limbs, it's called positive because it tells you what you can do, right? So the positive limbs state effectively that a taxpayer can claim a expense outgoing loss as a deduction if what? I think you know, right? So someone tell me. Someone tell me. I think you know the general deductibility rule, right? I'm sure you do. Tell me. Tell me what it is. When can you claim, in what circumstances can you claim a loss or outgoing, and an outgoing would include an expense, in what circumstances can you claim an outgoing or loss as a deduction to reduce your taxable income? I'm going to give you 20 seconds to talk to someone nearby about this, and then I'm just going to randomly ask someone. So in relation to the topic of deductions, what I'm asking you is the most fundamental question, right? It is the most fundamental question in relation to deductions, and what we're looking at here with, looking at various categories of expenditure, that's really about understanding particular categories and the case law, but it's still very much a derivation from the general principles, which we absolutely have to know. So, okay, so you better start the 20 seconds now, okay? And then I'm going to just ask anyone. You can talk with each other during this time. Okay, that's the 20 seconds. Right. Okay, now, volunteer? So, yes, Kim. Yes, in a sentence. Yeah, so in a sentence, in terms of, if I ask you, in what circumstances can an expense loss be deducted? Yeah, it's got to have a connection, right? So yes, that's right. Thank you very much, Kim. So in order to be deductible, the expense, outgoing, loss has to be incurred in connection with or in the course of generating assessable income, or incurred in the course of running a business, right? Okay, so that is the general rule. Now let us continue with our analysis of these various categories of common types of expenditure which have arisen in the cases, and you know, the courts have developed general sub-rules about whether a particular expense, you know, falling under these various categories is deductible or not. So let us consider expenses incurred in gaining employment. So the context we're looking at here is you incur expense, say it is you attend a job interview, right? Then you travel, for example, to Sydney for the purpose of a job interview. Say you even get the job. Would you be able to claim that as a tax deduction, the travel expense? Assume the prospective employer does not reimburse you. Yes or no? No, you would not. And then what would be the reasoning? Someone we haven't heard from. Yes, lovely. Yes. I like your explanation. Really, what you're saying is it's not related enough to the generation of assessable income. It's too remote. That's kind of a legal jargon word we would use to say it is really too remote, too distant from the generation of assessable income, right? And in terms of tax law concepts, we would say that expense is incurred in order to put you into the position of being able to earn assessable income. So let's have a look at a couple of cases here which have dealt with similar issues. So in the Madalena case, what happened was that an electrician, right, who was also a sports person, who was also a rugby player, he incurred travel and legal expenses when he was considering whether to change rugby clubs. And the question was, well, is it deductible? He was trying to claim a tax deduction. And the court held no, right? And I think it's quite analogous to the situation we talked about of you travel somewhere to attend a job interview. This is too remote from the generation of assessable income. Now, contrast, though, the result in Spriggs and Riddle. Now, here you had football players, a football player and a rugby player, sports people. So there is a similarity to some extent with Madalena, but there is a very important distinction too. So consider these facts. So you had a football player, a rugby player. They incurred management fees in negotiating employment contracts, right? And then the question is, are those management fees tax deductible for them? Well, the very important facts are that these two individuals, they were really different from the taxpayer in Madalena, who was an electrician and a sports person on the side. These two individuals were full-time sports people. And not only that, they were in advertisements, they were promoting themselves a lot, and in fact they were what we would call professional sports people. And when we start to use that term of, you know, a person is a professional sports person and they appear in advertisements, they're really running a business. And the business is themselves, right? And sports people, when they become very good and very successful at what they're doing, effectively the law regards them as being in business. The business is themselves, and they are in the business of, as the court put it in this case with the two individuals, commercially exploiting their sporting prowess, that is their sporting abilities, and associated celebrity's fame, right? So if you are so successful as a sports person that you are appearing on television and advertisements and you are effectively in business, then it's a different situation. If you are running a business, expenses you incur as a normal part of that business are deductible. And so because that is the context, the management fees for negotiating new employment contracts for those two individuals, it was held to be deductible. So I hope we can see the distinction between Spriggs and Riddle and Madalena's case, right? In Madalena's case, we're not told anything about the person being in advertisements, about having any kind of fame. It sounds like actually they were mostly an electrician that also played sport. So it's a different scenario. Now let's have a look at relocation expenses, right? So in Fullerton's case, the taxpayer, he was a forester. He had to move for work purposes, otherwise he would lose his job. He incurred relocation expense. It can be very costly, right? When you move and, you know, setting up house in a different location. And the question that arises from a tax point of view, can that relocation expense be claimed as a tax deduction? Well, in the tax law, it's very clear it cannot, right? It is regarded as too remote from the generation of assessable income. It is expenditure that puts you into the position of being able to earn assessable income, but not deductible. But thankfully, many employers do reimburse for relocation expense, either partly or fully. Like, case on point, ANU does when it recruits staff that live elsewhere. Yes. When they... You mean when an employer? Or no? Well, it's a reimbursement, right? You mean, does it have any tax consequences? We would not treat it as an allowance, right? I guess that might be the question you're asking, right, Pire? Yeah. I guess it's a very much a case-by-case analysis of whether, you know, it can be quite a tricky issue. That is a payment a reimbursement or an allowance? If it's an allowance, if it can be regarded as increasing the remuneration under the salary package, then it is taxed, right? But my understanding is that with the relocation expense, it is treated as a, we have this distinction between a reimbursement and an allowance, that it's simply a reimbursement and that there are no tax consequences for the taxpayer, right? Okay, so let us keep going with childcare expense, right? Now, it is very much the case that, you know, parents that work, they use childcare a lot unless they're lucky enough to have family helping them to look after their children. So what is the tax position with respect to childcare payments? Is it deductible? Many would argue that it is, you know, it is certainly a necessary expense for them, that they need to incur that expense in order to be able to work. What is your understanding before this course? Were you thinking, because people have some sense of tax, I think, in the community, even before they do tax law, that did you have any notion of whether childcare expense is deductible or not? Well, it's not deductible, right? It is subsidised, but not as a deduction, right? Well, I think in terms of the history of the law, the non-deductibility has been established for a long time. So, but as a matter of policy, the government thinks this is an area where we should be helping parents and does provide some generous tax rebates, right? And it is subsidised, yes, childcare centre is subsidised, and you get the tax rebates. But it is not deductible. Now, if we want to analyse that in terms of first principles, how we would analyse it is to say, well, actually there's two reasons the law gives. The law says it's of a private or domestic nature, right? Too private or domestic, not connected enough to the generation of assessable income. And then there's also the further reason, which we have seen before, right, where the court takes the view this is expenditure that is too remote from the generation of assessable income. It merely puts you into the position of being able to generate assessable income. So not deductible, okay? But you can get some tax benefits by way of rebates. Now, what about travel expenses, right? There are a number of subcategories that we will look at here. Now, let's start with the general rule. Travel expense from home to work and work to home. General rule, can you get a deduction? No, very clear you cannot, right? And again, it's the same reasoning, right, that we've mentioned a couple of times already, that the court thinks this is too remote. It merely puts you into the position of being able to earn income. Right, that's the general rule. However, let's be aware of some special categories where, well, either you can think of them as exceptions or you can think of them as really these are special cases. That's probably more accurate, where the general rule doesn't apply. So let's have a look at the special cases where in these special cases you can get a tax deduction for travel to work. So the first special case is non-routine travel to work. So a case illustration is FCT and Collings. Now here you had a computer consultant. She had started to work from home. She mainly worked at home, but from time to time, when she couldn't deal with a query from home, she went into the office to deal with it. And in that situation where it is unusual, right, and it very much, I think, how we can rationalize it in just even a little bit of a logical way in terms of first principles is her travel really has a strong work character to it. When most of the time she's doing her job from home, she's a computer consultant, but sometimes it's just not possible to fully resolve the query from home, so she goes to work to deal with it. It's really made very necessary by perhaps the complexity of the query, and in that situation she can get a tax deduction for the travel to work and back, right? So non-routine travel to work. Then a further case where we can get a tax deduction, it's similar to, you know, it's non-routine again, where you go to an alternative place of work. So travel to and from an alternative place of work, provided this is not some kind of regular arrangement, provided it is unusual. There's something unusual about it. For example, if you go to, say, a client's premises, say a few times in the month, right? Whereas normally, say you go to the firm's office in the city to do your work, say you are an auditor, but say in the month of August you went 8 times to the client's premises from your home, 8 times isn't so frequent, that should be deductible. That's what we mean by going to an alternative place of work, right? That particular example, I, long time ago, put that into an exam question, just that, you know, it was only a small part of a question, but it was part of it was in the facts there, and that expense should be deductible there. And the authority for saying that you can get a tax deduction there for going to and from an alternative place of work is that tax ruling cited in the lecture slide. Right. Now, going to another special case. Now, actually, I like this one because it's very clear, right? I mean, I think the alternative place of work scenario, it's a little bit uncertain, right, in terms of, well, what level of frequency would be all right. There are some uncertainties. But this next scenario, this next subcategory of where you can get a tax deduction is very clear. For itinerant workers, where travel is a fundamental part of their job, they can fully claim their travel expense as a deduction. The classic example is a travelling salesperson. If you are a travelling salesperson, travel is a fundamental part of your job, and all of your travel expense from the moment you leave home to when you come back, all your travel expense is deductible, and it's very clear. Analogously, for a relief school teacher, travel expense is deductible. By a relief school teacher, we mean a school teacher where they don't have a regular school. But these they exist in the public systems, certainly, right, and perhaps even in the private system, that you have school teachers where they provide cover, right? If the regular teacher is sick, for instance, they provide cover. They come to take the class. They don't have a regular school that they go to. Now, this issue arose in Vina's case about the tax deductibility of the school teacher's travel expense. And the court held that for relief school teachers, because they're travelling all the time, it's a fundamental part of their job, they don't have a regular workplace, they're going to different workplaces, it could be a different workplace every day, the travel expense, all of it is deductible. From the time they leave home to the time they come back, all of it. Now, there is an error in your book here in the description of the facts of Vina. I mean, the facts that are quoted in your book are really extraordinary. It says that the school teacher was working in 4 different schools a day. I just thought that was extraordinary. 4 different schools in a day. And so I actually looked up the case report, and there is an error. What it is this teacher is working about 5 schools per week. Okay, that's more reasonable. That's manageable for, you know. But even that, 5 schools per week is a lot, 5 different schools per week. And in that situation where it's really travel is so integral to the job, right, that it's fully deductible. Now, a further situation where you can get travel expense as a deduction. Now, it's an interesting one. I think it's logical. I think it makes sense. If you need to carry bulky items, bulky work items that are needed for your job, if you need to transport them from home to work and work to home every day, right? Then you can claim the travel expense as a deduction because your travel then takes on a work character, right? You are carrying a work tool with you from home to work and work to home. Now, in what sort of situation would this apply? It will only apply where you really need to take that work tool home. And so in the case of a professional musician, that's what arose in Vogt's case. The court said, yes, you really do need to take your instrument home and then back to work and home, because, you know, with musicians, it's necessary that they practice every day. But contrast Brandon's case. If you are taking your work tools home just as a matter of your own choice, for your own convenience, because you want to, but not because it's necessary, then you won't be able to claim a tax deduction for the travel expense. And that's what happened in Brandon's case. Here, the taxpayer was a soldier, right, an Australian soldier, and he was taking his deployment kit home, right, you know, and where he didn't need to. This could be stored, right? This could be stored at the barracks at work, right? He didn't need to take his kit home. And the court said, no, you cannot claim a travel expense as a deduction in this situation. Right, now let's get to a question that arises quite a bit, okay? This one that, even amongst professionals, this would arise quite a bit. When is travel between two workplaces deductible? Right. Now, the professions where it would arise quite a bit, the one that immediately comes to mind are doctors. It's very common for a doctor to work in both a hospital and also to have a private practice where they see patients. Now, so if we ask the question, is the travel expense between the hospital and the private consulting rooms of the doctor, is that deductible? Very clearly, yes, right? Now, under Division 8, that's the general deductibility rule, you can certainly claim as a tax deduction the travel expense between two places of work where it's the same income generating activity, right? So in the example I gave you with the doctor, it's medical services in both situations. And if it's the same kind of income generating activity, then definitely it's claimable as a deduction under Division 8. Now, let's consider the situation we had, the very kind of, I think, unusual situation in FCT and Payne, where you had travel between two workplaces, but they related to different kinds of income-generating activities. You had a Qantas pilot. He was not only a pilot, he had a deer farm. He was running that out of his residence, and he tried to claim a tax deduction for the travel expense between the airport and his home where he had a deer farm. The court held no, that you cannot claim that as a tax deduction under Division 8. They must relate to the same kind of income-generating activity. Parliament responded to that decision by enacting Section 25(100) of the 97 Act. And this is a rare instance where Parliament thinks that the taxpayer really ought to get a tax deduction, right? Normally Parliament is restricting deductions, but in 25(100), the legislation provides, and it was enacted after Payne's case, that a taxpayer can get a deduction for travel expense between two unrelated places of work, right, in the sense of it's different kinds of income, different kinds of services, right, that we're talking about. But there is a qualification, which means that the outcome on the specific facts of Payne wouldn't change. The qualification is one of those workplaces cannot be your home, right? If it's your home, then you can't get get the tax deduction. So it's actually going to be the same result in pain, right, if it happened today after 25-100, because it was his home where he operated the deer farm. But if we change the facts in pain to locating the deer farm somewhere other than his home, then he could get the tax deduction today based on 25-100. So 25-100 is a specific deduction provision, okay? So it's the deductibility, it's based on that, 25-100, not Section 8.1. Okay, now this is the benefit of coming to lectures. I not only tell you what is important for examination purposes, I tell you what is only for your information and what I will not examine. This next slide is purely for your information. I'm not going to examine it. It's just too tedious and too administrative, right? It's telling you about the mechanisms for deducting travel expense and car expenses, and how would you go about it? Well, I'm sure if you ever had to do this, or if you were advising a client, you can look up the law, you look up ATO web pages. And the thing is, this changes. In the last 2 years, this has changed. Until about 1 or 2 years ago, there were 4 different methods we could use. Now there are 2 methods, so cents per kilometre and the logbook method. 2 different ways where you can really, keep track of travel expense, and you have to use one of these 2 methods to claim your deduction if it's a situation where you can claim a deduction for travel expense. Okay, so I'm not going to ask you any questions about this slide. It's just to let you know it exists in the law, and if you ever need to find out, you can look it up. It might have changed again by the time you need to be concerned with it. Okay. Let us go to now self-education expense. This is a really interesting category of deductible expense. As a general comment, I would say the law takes a very liberal approach, right? I think in some categories like travel expense not related to self-education, right? I mean, the reason I say that is because you can have self-education that has a travel component, right, and where the law is very liberal. But if we are talking about travel expense, if we look at the general rule, home to work travel, work to home, I think the law is very strict. We do have those exceptions, but overall I think the law is pretty tough there. When it comes to self-education, it is really liberal about the circumstances in which you can claim a tax deduction for self-education expense. So I think you'll see that in the cases. So what do we mean by self-education? We mean that the taxpayer is undertaking some educational course related to their study. It could be the taxpayer is going to a conference that's related to their work. It could be that the taxpayer is purchasing journals and books related to their work. So we are talking about the taxpayer advancing their knowledge and skills that are relevant for their work. Now, provided it is clear on the facts that the particular course or the particular conference is related to the taxpayer's work, a deduction would be available. And now in the cases, and also, well, I think particularly in the commentary in your book, there's a lot of emphasis placed on the rule being self-education expense is deductible if the expenditure would increase the taxpayer's chances of promotion or earning a higher income in their career. Well, if it can do that, certainly it's deductible, but I think that to place an emphasis on promotion or earning a higher income actually states the test too narrowly, because I do not read the cases as demanding that. And in fact, the cases make clear, and the judgment of Justice Hill in Student's case makes clear that an expense will be deductible as a self-education expense if it's shown that that expenditure, say it's some lessons or a course, will help you to do your job better, somehow to do it better, even if you can't show that it would increase chances of promotion. That doesn't matter, right? And when we get to Student's case, I'll tell you a little bit more about Justice Hill's judgment, because it's very interesting. So I'll continue on with this point. But just to let you know how I've stated the rule is wider than the language in your book, but it's because I believe this is the rule. This is the accurate rule. It's not just about it'll help me get a promotion or help me earn more money. If it will help me do my current job better, that's good enough. The courts will let you have the deduction, right? Okay, let's have a look at some cases. FCT and Hatchett, 1971. We have to note it's 1971 because I think the result would be different if it was decided today. I think all of that expenditure would be deductible today. Sometimes the outcome can really change depending on changes in social circumstances, changes in the economy, right? So here in Hatchett's case, you had a school teacher. They incurred expenses on an arts degree and a teacher's higher certificate. In 1971, the High Court concluded that only the expenses relating to the teacher's higher certificate were deductible, and held that the expenses relating to the arts degree were not deductible, thought they were not the arts degree was not necessary, it was only recommended, and would not directly lead to promotion. Okay, look, that is a long time ago now, 1971. You know, it has been the case for a while that school teachers need an educational qualification from a university, right? I mean, it's been commonplace for about 20 years or more that to get a job as a school teacher, you need an arts degree or a Bachelor of Education. It could be both, Bachelor of Arts, Bachelor of Education, right? So that this has changed, right? The social circumstances, the economic situation, the market forces, what's expected has really changed. And I think if this case came before the court today, the court would say, arts degree necessary, right? Necessary and would be deductible, okay? Now let's go to Student's case, really interesting case. So the taxpayer in Student's case, he was a flight engineer. He took some flying lessons and he claimed the cost of the flying lessons as a tax deduction. The commissioner disallowed the deduction. The commissioner argued, well, this is not related enough to your current career as a flight engineer. We think, the ATO thinks this is you just acquiring skills for a new career, potential new career as a pilot. Well, the case went to court, and the court is not concerned about going into people's minds about their intentions, right? About their what are their heart's desires. The court is not concerned about whether this flight engineer has a desire to be a pilot in the future. In terms of tax law, all the court cares about is there a relationship? Is there enough of a relationship between the flying lessons and your current job as a flight engineer? Is it possible that by doing flying lessons, you can be better in your job as a flight engineer? Now, I mean, this is really a kind of a technical question, and judges without evidence, they probably don't know how to answer that question. So very often in court cases, you need expert evidence presented, right? And expert evidence was presented. And the expert evidence was that, expert evidence is going through, what a flight engineer does, what's required to be a good flight engineer. And the expert evidence indicated to the court that by taking flying lessons, you can do your job better as a flight engineer. Sort of makes intuitive sense without really knowing anything about it even, but the court was presented with that evidence. And so having been presented with that evidence, the court held, yes, it's deductible. Therefore, the flying lessons are deductible. And then in Justice Hill's judgment, and he's got a really, deep knowledge of tax law, and then it's really his judgment that I rely on for the point that I think the commentary in the book and other books really state this principle too narrowly, right? You don't have to prove that an expense will increase your chances of promotion or will increase your chances of making more money. It's sufficient, as it was in Student's case, to show that these lessons will help me do my job better. That's enough. And then Justice Hill, I really like this, made this really interesting comment. It was directed right at the Commissioner of Taxation. Justice Hill said to the Commissioner, there are situations where, look, it's not possible for an expense to increase chances of promotion or earning a higher income, but it will nonetheless be deductible under the law because it helps you to do your job better. And the example Justice Hill used was, what if, now, I think, can the people who are talking pay attention? Right, thank you. And the example that Justice Hill gave was, what if you, the Commissioner of Taxation, undertook some taxation law courses to advance your knowledge of tax law? That would be deductible for you, even though you can't get a promotion because you're already at the top of your career. It would be deductible, right? So it's a really colourful example. You don't need to show increased chance of promotion. Pire. Yes, I mean, it's deductible to the extent it's not reimbursed by their employer. Certainly, it's absolutely relevant for their work, right? So I know a lot of firms do pay for that, but to the extent it's not reimbursed, certainly you can get a deduction. Okay, so continuing on with self-education expense, so from the tax ruling, TR 989, and I posted this to Wattle, it makes the point, if you are working in a profession that requires you to be continually up to date, then any expenditure you incur for that purpose, whether it's getting journals, whether it's subscribing to newsletters, whether it's going to conferences, that will be deductible, right? I mean, there are, the profession I think where it's most important to be up to date is medicine, right? I think more than any other profession, doctors need to know what the latest drug treatments are, what are the most beneficial drugs, what are the side effects, and to really know what's going on in their relevant area of medical practice. So certainly, for a doctor, any journals they subscribe to, any conferences, seminars they attend, all of that will be tax deductible. Now, same applies for other professions, but I just gave you medicine because I think that's the most compelling case. For accountants and lawyers, it's very common for them to go to conferences and seminars, and there are a lot of them around. Provided that connection exists with, it's related to their work, then it will be deductible. Right. So now let us keep going. Now what we're going to look at is the Anstis case, which I did mention last week. It's a very interesting case. Now, this is dealing with self-education expenses that are not related to employment income. This case deals with a university student. She was a student enrolled in the Australian Catholic University. This was a test case that went to the High Court, and it actually made the newspapers, right? She was successful in the High Court. And if you look at the facts, you see actually it's not really that much money at stake. Well, I haven't got the amount of the deductions there. I've got the amount of the youth allowance, which is $3,622. The amount of the deductions total claim was around $920. So you might wonder, why would a university student, go into a legal dispute and have a case before the High Court? And in terms of the amount of the deductions we're talking about, it was total around $920. Well, now I might have mentioned this to you before. Who's driving this? Who's taking it to the High Court? It's actually the Commissioner of Taxation, not the university student. Yes, she is the taxpayer, and yes, she made it onto the newspapers and a nice picture of herself because she was successful, but she didn't incur any legal expense. So don't worry about that if you're thinking about the poor university student going to the High Court. What happens, and this is very common for the Commissioner of Taxation, they often want to run a test case and they agree to pay the other side's legal costs fully, no matter what the outcome. So that's how it went to the High Court. The scenario. This university student, she was receiving youth allowance payments from the government. Now, in Anstis, the High Court confirmed that youth allowance payments are assessable income. Okay? It's not based on nexus with an earning source, right, which is our main basis for capturing receipts as income. It is this special tax concept of applying where some receipts, simply because they are expected, depended upon and relied upon by the taxpayer, they are treated as income. So youth allowance, that is one example. Another one is government age pension. Right. So that is income. Now, the question is, are these expenses that she incurred, computer depreciation, textbooks and stationery, are they deductible against her youth allowance income? Can she reduce her taxable income by claiming these particular deductions? Now, what is the argument? The argument, and it's really a single judge of the federal court that went through the reasoning, and then it was accepted by the full court of the federal court and the High Court. The reasoning is as follows: that in order to get these youth allowance payments, which are assessable income, she needs to make satisfactory progress in her degree, right? It is a condition of receiving youth allowance, which is assessable income. She needs to make satisfactory progress, and in order to make satisfactory progress, she needs certain study tools. She needs a computer, she needs textbooks, she needs stationery. That's the reasoning, right? That these expenses are necessary in order to make satisfactory progress in a degree, and satisfactory progress is needed in order to get that assessable income. So that's the connection between the expenditure and the assessable income, right? The High Court accepted that reasoning, so that's the answer. The High Court concluded that her expenses for computer depreciation, textbooks and stationery are deductible because they are productive of youth allowance. They are needed in order to get that youth allowance. There is that connection between the expense and the assessable income. It doesn't matter that she's not a teacher yet. It doesn't matter, right, that's what she was studying to be. It doesn't matter that she hasn't got employment income. The income that we're talking about here is the youth allowance, and we've got the connection. How did the government respond to this decision? This is where last week we briefly mentioned ANSTIS because I told you about how the government responded. How did they respond? Anyone know? Anyone remember? They reversed it by legislation. They didn't like ANSTIS. They enacted Section 2619, right, which you have in your list of denied deductions. So the High Court gives us ANSTIS saying, yes, you can claim these items as deductions against youth allowance. The Parliament doesn't like the decision. They enact a statutory provision that says you cannot claim any expenses related to, the term used is rebatable benefits. The government is taking and youth allowance is a rebatable benefit. The government, from a policy point of view, is taking the position, well, we are being very generous by giving you youth allowance, and therefore we think, look, that's enough in terms of our generosity. We're not going to allow you to claim allowable deductions that will reduce the taxability of that youth allowance. Okay? So, yes, that was the decision, but it was reversed by legislation. Okay, now, let us do this slide and then we'll have a break. Travel expenses related to self-education. This is a really interesting area, right? And what is the approach of the court? Incredibly liberal. I think in terms of deductions, this is as liberal as it gets, right? And the court really is not consistent in terms of, as I said, I think in relation to the normal work-home travel, it's very strict. But when it comes to self-education travel, it's so liberal. And you should be aware of that because all of you are going into, actually I think all of you are going to be, or nearly all of you, perhaps all of you, are going to be professionals, right, of some kind. Could be accounting, finance, or it could be you have your own business. I think there could be a large capacity, large scope for you to undertake travel that has a self-education component, right? That in some way you're advancing knowledge that's relevant to the profession you're in. Think about self-education expense, large scope to deduct. Right, so what are we talking about? We're talking about a taxpayer going to some destination, could be domestic, could be overseas, where it's often a conference, and what can they get as a deduction? Well, if that conference, for example, is clearly related to their work, that's the question you ask, is it related? They can get fully as a deduction the cost of that trip. You can get the conference registration, you can get the airfare, you can get all the surface travel, you can get all the food expense, right? Once the law determines that that trip has a work character because it's related to your job or your business, then all the trip expenses are deductible, right? Accommodation, airfare, surface transport, food, right? Where it's going to be more complicated is if this trip has a partial private or domestic purpose, then apportionment will be needed, right? Now, let us look at some cases. Finn's case is the major case. It's a High Court case. Now, here you had a taxpayer who was an architect. He worked for the West Australian government. He used his leave to travel overseas. Now, note that a trip can still have a work character under tax law, even if you are using annual leave or long service leave to do it, right? Just note that. So he used his leave to travel to Europe, UK, and South America. And the purpose of his trip was to study architectural trends, or, in these overseas destinations. Now, his employer, the government, supported this trip. They thought it would be beneficial for his work. And one very important fact, it was his employer that asked him to extend his trip to South America. Initially, he was only going to go to Europe and the UK. And in fact, his employer paid for the part of his trip related to South America. Now, that's very important evidence, because not only is his employer telling him to go to South America to observe architectural trends, the employer is actually paying for that part of the trip. That means there's very strong support from the employer for the trip. And the fact that the employer supports South America also indicates that even observing the architectural trends in Europe and the UK are likely to be very beneficial for work purposes, because what we know from the employer's support of the South American aspect is that in principle the employer believes that observing architectural trends elsewhere in other countries can help him do his job better in Australia. Now, without getting that sort of evidence, as a layperson, at least me, I would be a bit skeptical about, well, yes, we know architecture it's very visual, but is there really enough of a connection with your work in terms of going overseas to observe architectural trends? It's really something where we need evidence. And I think actually he has a very strong case simply because of the employer's support, right? So what did the High Court hold? The High Court held that all of the trip expenses, the unreimbursed part, right, relating to UK and Europe, was a tax deduction. And the reasons, right, the reasons are, one, employer endorsed the trip, employer supported the trip, and really strong evidence of that. They're even paying for part of it. Two, the taxpayer had extensive information collated from abroad, right? Now, if you are thinking about in the future claiming a trip as a tax deduction on the basis that it's a self-education expense, that it's related to your work, what you should do is keep an electronic diary, right? In real time of what you're doing, and also take a lot of notes and have the evidence, right? Because the more evidence you have, here the architect, had extensive notes, extensive information, I think extensive photography, the more it supports the case that this is a work trip. And then the third point was the court was convinced this did increase his knowledge and did increase his chances of promotion, right? So deductible. Now, I think you can look up yourself in the book, and look, don't worry too much if you don't have the book, but because there's simply further illustrations. But if you do have the book, you can look at Lenton's case and Carlos Sanchez for yourself. And I think they show you how liberal the court is here, right? In the Lenton case, the taxpayer was allowed a 75% tax deduction for a trip to Asia. And I think Asia was the major destination. And he called the trip a self-guided educational discovery tour. He was a high school teacher, and the thing was, he did not attend any formal lectures, say at a university. He didn't go to any conferences. About as formal as it got in terms of education was that he listened to lectures at museums, right? So just imagine that situation. Someone is going overseas, they're not going to any conferences, right, where there's actually a registration fee. They're simply going to museums and they're listening to some lectures at museums, which maybe some of you have done that on your holidays, right? What kind of a deduction is he getting? 75%. It's very liberal, right? That case, the court's approach. Carlos Sanchez, that concerned an STA travel agent who went to some, overseas destinations. Well, it looked like a holiday, but the STA travel agent was able to get a partial tax deduction. The tribunal approved this, a partial tax deduction, on the basis that as a travel agent, the more holiday destinations you've been to, the better you can do your job as a travel agent, right? It's pretty liberal, I think, even to get a partial deduction there, but he did get a partial deduction. I don't have the exact amount, but it's the fact that you can get any deduction there. Okay, so let us have a 5-minute break and then we'll come back. has been a bit more than 5 minutes, so we are going to continue with the lecture. So wait for everyone to pay attention. Thank you. Right, so continuing with self-education expense, and this actually I had a question related in the break. So in relation to tuition fees, right, say fees for university courses, so could we have everyone's attention, please? Yes. Can you claim that as a deductible self-education expense? Yes, potentially if it's related to your work. But note a qualification. If those tuition fees are already subsidized by the government by way of HECS or HELP, right, and it's domestic students that are eligible for this, then the tuition fees cannot be deducted. Because the government is taking the position, they're already helping enough by subsidizing the tuition fees, right? And it's Section 2620 that says that. Now, Section 82A of the 36 Act, we'll just note that, and I'll tell you what it means, that I think it's actually a rule that should be repealed in the law. It is an administrative hassle where the costs of administration or thinking about it exceed the benefits, and so for that reason I will not ever in a marking guide deduct any marks for if a student doesn't consider 82A, okay? But how it works is this, right? Section 82A of the 36 Act provides that the first $250 of self-education expense are not deductible, right? It appears to say, well, it's only after you spend more than $250 that we will, that the government will allow you to have a deduction, right? However, now this is another reason why I just don't mind if students say nothing about this rule, is that usually, most of the time, this rule is not actually a hassle, right? And you don't have to even worry about it because the scope for it to operate is severely reduced by the fact that in working out whether you've incurred $250 worth of self-education expense and to work out whether you can start deducting, you can take into account, for the purposes of that 250 threshold, any expenses that are causally related to self-education, even if they are not tax deductible, okay? So what that means is expenses like childcare, expenses like, say, the capital cost of a computer, whereas normally it's only depreciation that's deductible, you can take into account in knowing whether you've hit this 250 threshold. So I'll give you a really simple example of what this means, okay? Now, say you attend a conference related to your work. The conference cost is $1,000. It's a one-day conference. To go to this conference, you had to hire a babysitter or get childcare, right? Now, I'm going to make it really easy. The cost of that childcare is $250, right? Now, what does that mean? It means you have hit the 250 threshold. You don't have to worry about it. Your tax deduction in terms of the conference is the whole $1,000. Okay? Say you were in this unfortunate and I think unusual situation where you had no other expenses causally related to the conference. Then it means technically you can only claim $750 of the conference cost if it's $1,000. But that is very unrealistic that you wouldn't have any other expenses. Because, for instance, you had to get to that conference, right? Yeah. I mean, well, all of that would be deductible. But, so basically that's what it means. But I don't expect you to really incorporate that into your answers. Now, just a point from TR 98.9, which is posted to Wattle. This is the idea of it's getting more complex in terms of situations we see in real life, that often it is the case that there's a work component to a trip and a recreational component, because the thing is that a lot of the conferences that happen in the world are in very nice destinations. That's how they get people to come to the conferences. And there is often a holiday component as well. Now, so what if there's really more than one purpose? Well, there is an apportionment that needs to occur. Now, there are a couple of interesting examples in your book around page 443, and they're extracted from the ruling. So the rules are, if the main purpose of your trip, say by far the main purpose of your trip is it to go to a conference, maybe that is the purpose of your trip, but say a small part of the time involves some sightseeing, you would still be able to get the full airfare, right? You don't have to apportion, right? If you go somewhere for a conference, right? Say the example is you go somewhere for an 8-day conference, one day, say it's 8-day trip, okay? 8-day trip, say one day involves sightseeing. Yeah, that would be, look, the trip is for the conference. You can still get the airfare fully deducted. You can still get the full accommodation cost deducted, and that recreational component would be seen as purely incidental. Now, in particular, in the example given in the tax ruling, which is extracted in your book, it's very clear-cut that you could get everything as a deduction because the sightseeing is actually organised by the conference. You have that often in real life, that the conference itself organises, it could be part of a day as sightseeing, then it makes it really easy, that the whole thing just has a work character. You can certainly get the whole airfare, the whole accommodation costs, all the food, right? Now, let's go to the other extreme. You're going really on holiday somewhere, but you notice that there's a seminar on that's related to your work, and you go to that seminar. What can you get as a tax deduction? Right? Only the costs of the seminar. Okay? And that example is in your book. In that case, you cannot claim any part of the airfare, you cannot claim the accommodation, but the costs directly for the seminar you can claim as a tax deduction. Now, in the tutorial, we'll go to sort of a further situation, which is sort of in the middle. What we've presented here are two extremes. One where it's a work trip with a bit of sightseeing incorporated, and the other extreme of it's a holiday with a work-related seminar. There's also a lot in between, and in the tutorial we'll go through a situation in between. It could be, where sometimes you can have a situation of two equal purposes, of you go for a conference and then followed by a holiday after that, okay? And we'll look at how to deal with that in the tutorial, but it will be could be sometimes even a 50-50 apportionment there that occurs if you have two equal purposes. And around paragraph 70 of the tax ruling, TR 98.9 is directly relevant for that, okay? So if you want to selectively, you can selectively read parts of the ruling, that would be great. Have a read around paragraph 70 of TR 98.9. Okay, now let's keep going. We are looking now at home office expenses. Right. Lots of people have a home office. Right? Now, can you get a tax deduction in relation to home office expenses? Well, it depends. It depends what kind of a home office it is. If your home office is really what we would call a home study, and lots of professionals have that, they have an office You know, that where they go somewhere to work every day, but they've also got to study at home where they might do some work. Okay, that's what we would call a home office for convenience only. With that sort of a home office, it's very limited what you can get as a tax deduction. You would only be able to claim a portion of running expenses as a tax deduction in that situation. By running expenses, we mean things like electricity, cleaning costs, depreciation, right? Could be depreciation on your computer, depreciation on furniture that's used in the study. Now, I hope everyone's paying attention. So, no private conversations, otherwise I might ask you a question. Now, okay, so you got it? If we are talking about a home office that's just a private study, like a study at home, which a lot of people have, it's very limited, okay? It's just a portion of running expenses, right? The electricity, you have to estimate it. The additional electricity you incur because of your home study, right, you can get as a deduction. You can get depreciation related to your computer, your furniture, okay? You can get a portion of running expenses. Okay, now, if it's a different kind of home office, if this office, even though it may be structurally in the same building as your home, if it has the character of a place of business, that's a completely different category. I wouldn't even use the expression home office to describe that. Right? It is simply that it's structurally part of the same building. But if it has the character of a business, right, then it's really extensive what you can claim a deduction for. You can get a portion of not only running expenses, but a portion of occupancy expenses. And these are the really big ticket item expenses. A portion of your rent or interest on the mortgage, if you own it, insurance, a portion of insurance, a portion of rates. These are really big expenditures, right? And how much would you claim? It would be based on floor area. You look at the building, well, how much of it, what proportion is an office? Say if 40% of the building where you also live as your home is you use it as a place of business, then you can claim that proportion. You use the floor area. If it's 40% floor area, you can claim 40% of your rent or interest on your mortgage, 40% of insurance, 40% of rates as a tax deduction. So it makes a huge difference what kind of a home office we're talking about. How do we distinguish between a home office for convenience only and a home office which is really a place of business where you can get occupancy expenses as a deduction? Well, the tax ruling TR 9330 gives us some considerations that we look at, right? You look at, is the area clearly identifiable? Does it look like a place of business, right? Is it readily usable for private purposes? If yes, then unlikely, right, to be considered a place of business. Is it exclusively or almost exclusively used to carry on a business? Is it regularly used for seeing clients or customers? If yes, then it looks like a place of business, right? I think the main thing is when you look at it, right, it has to look like it's professional, that it's a business. Now, I have been to such offices. I have been to lawyers' offices. I've even been to doctors' offices where it's structurally their office is in the same building where they live with their family. But it's very professional. When you go into that office, it's a separate door to their private home. You can't see anything of their home, right? You go into, usually if it's lawyers or accountants or doctors we're talking about, you go into a reception, there's a secretary. It's all very professional. You can't see their family. You can't see their kitchen. You can't see their lounge, right? It's walls separating their work life from their family life. That is a very clear case where you've got a place of business that just happens to be structurally connected to the home. In that situation, of course, you can get a portion of occupancy expenses. You look at, in terms of the building, what proportion is the office, and you can get that proportion as a deduction. Okay. Yeah. If it's not separate, you mean what would be this? It's not separate? Okay. Then look, the thing is, if you're conducting a hair salon, right, from your home, I mean, look, it sounds like you've got a business, right? Oh, it depends what scale it's on. It sounds like you've got a business, but I mean, they really should have some separation, because if you have a genuine business, then you ought to be claiming the deductions relating to that, right? I mean, to me, I would expect that there surely must be some separation. Or they need some advice to get some separation to ensure that they can get the deductions that they are entitled to, right? But it is a problem in the tax law in terms of, say, if the ATO audits, that they do want to see the separation, right? Now, Swinford's case, I think it's a bit of an unusual case. It's because of what they did for a living. Now, in Swinford's, there was not that strong separation, but I think the context matters, and they were allowed a deduction for occupancy expenses. You had a self-employed scriptwriter who used one room of their flat for writing purposes and for seeing clients, right? And they were entitled to a tax deduction for a portion of their occupancy expenses. Now, here I think it matters what they did for a living. Look, they're not it's different from the case of the lawyer, doctor, and even the hairdresser. It is, they're this artist person, right? And look, they often conduct business in all sorts of places. And they're seeing the clients in that room. I can see it that for that situation, and they didn't have an alternative office, they are allowed a tax deduction. But in general, I would say the key factor is, as per these guidelines, you are looking for, does this area look professional? Does it look like a place of business? If so, you can get a portion of occupancy expenses as a deduction. Now, if you are a person like the scientist in Fashni's case and like the lawyer in Handley's case, and these cases are at pages 446 to 447 of your book, these taxpayers were, I think, very cheeky. They had a home study, look, like so many professionals do, and they were claiming a portion of their rates, of their insurance, of the interest on their mortgage as a tax deduction, simply based on the fact that they had a home study. These cases, they both went to the High Court. The court held no. You cannot claim those as deductions just because you have a home study. This is not, it's nothing like a business, right? So at most, all they can get here is a portion of running expenses, a portion of electricity, heating, depreciation, right? And as I mentioned before, if you do have a place of business, right, that is structurally in the same building as your house, you can apportion the occupancy expenses based on floor area. Okay, let's keep going. Now we're going to look at the deductibility of clothing expenditure. Right. Now, the main point is that expenses relating to conventional clothing are not deductible, right? Now, what is conventional clothing? What we call conventional clothing in tax law are, clothing, normal clothing that we wear in day-to-day life. They can be professional, right? It can be suits, right? That is still considered conventional clothing, right? Even though you may need to, for the purpose of your work, wear very, suits of a very professional nature. You may think that you have to spend a lot of money on clothes because of your job. General rule, you can't get any tax deduction for that, okay? Even if you've spent thousands of dollars, when you start a new job on suits, no tax deduction. It's considered conventional clothing that you can wear in day-to-day life. Look, even if it's very professional. Now, let's have a look at some sort of special cases where you can get something. In relation to uniforms, yes, you can get a tax deduction. If it's the case that you are required by your work to wear a particular outfit, right? Like the white dresses that nurses have to wear, right? That is claimable as a tax deduction. Now, in addition, if it's the case that you have to wear certain protective clothes because of the nature of your work conditions, you can get a tax deduction for all of that protective gear. So that arose in Morris's case, where you had a number of taxpayers where the common factor was that they had to work in the outdoors. There was a lot of exposure to the sun, and for those taxpayers, they could get, the hats, sunscreen, any other protective items for construction workers, the hard hats, that's a protective item, all tax deductible. And you can see, I think, for people that work in hazardous conditions, right, and the sun is a hazard, right, and of course construction sites are hazardous. There's also, I think, a strong policy incentive for reason that they really should be deductible, those expenses. And I think if the court hadn't concluded that they were deductible under Section 8.1, I wouldn't be surprised if the Parliament enacted a specific deduction provision to state that they are deductible, right? So uniforms are deductible. Protective clothing and protective accessories and things you need to be safe in your work environment, like sunscreen if you work outdoors, that is deductible. But conventional clothing, not deductible. Like, let's have a look at a couple of cases. Case U80. You had an employee working in the department store David Jones. At least at this time, they were required to wear black. She said, oh, black doesn't suit me, I can't wear black outside my work. She wanted a tax deduction. The court held no. It just doesn't matter whether you wear black outside the home or outside your work or not, right? It is conventional clothing. Westcott and FCT. Now here you had a head waiter. He tried to claim a tax deduction for the black trousers that he wore at the restaurant. Again, he claimed, oh, he just doesn't wear black trousers outside the restaurant. Court wasn't interested. It was, well, it's the nature of that item. It is conventional clothing. It's not allowed as a tax deduction. But, what they did allow him a tax deduction for was his abnormal dry cleaning expense. Because he was a waiter, it was constantly spills on the trousers, and he had a high dry cleaning expense. The court said he could have a tax deduction for the dry cleaning expense, but not for the cost of the trousers. Now, let's have a look at the case of FCT and Edwards. It is a very unusual case. If you have an extraordinary case, like from time to time, you will get these sorts of cases very occasionally, where a person is required by their job to incur a very high level of clothing expense, right? I mean, it's something on a far greater level than, the professional suits that you might have to buy for, working in an accounting firm or a law firm. If you have a case where it's something similar to, or it's hard, this is a very unusual case, so I don't think you're going to find another case similar to this, but if you think that you've got a case in real life where it's very abnormally high, the level of expenditure on clothing, and it is required by the job, then it's possible to have a tax deduction, and you can get a tax deduction. It's for that abnormal component of the expenditure. So let's have a look at FCT and Edwards. It's a really memorable case because it's very unusual. Now, the taxpayer was the personal secretary to the wife of the Governor of Queensland. Now, her job required her to live at Government House, so she lived in the same complex as the Governor and his wife, and she was with them 7 days a week. Presumably she had some annual leave, but her regular life was living with them at Government House and 7 days a week. Now, as part of her job, she accompanied the Governor and the Governor's wife on all their functions, and this involved a lot of travel, and it involved multiple changes of outfit per day. She was required to dress, in a certain very professional manner during the day, and in the evening to wear, evening gowns and that sort of thing. So it's very unusual case. And in fact, in the period August to November 1990, she purchased 51 new items of clothing for her job. And we're also told from the facts, when she's travelling, there's limited laundry facilities. She can't just wash a few items. She needs a lot of clothes to perform her duties. Well, I think you get the picture. It's a really strange case. And the court said, on these facts, you can have a tax deduction, right? You can have a tax deduction for the abnormal component of the expenditure. What is that? Well, how you'd go about calculating it is, what the court suggested is, she has to show what her expenditure on clothes was in, say, the 2 years before the job. And then you compare her expenditure after she got the job and the abnormal component she can get as a tax deduction. Right, now let's move on. Let's talk about interest expense. When can we get interest expense as a tax deduction? Well, we apply the general rule. If the interest expense relates to the generation of assessable income, yes, we can get it as a tax deduction, and it will relate to the generation of assessable income if we borrow money to buy an income-generating asset, right? So let's go back to Steele's case. Ms. Steele, she was intended to establish a motel business, never ended up constructing the motel, but she did buy the land, the major asset of the business, and she was very serious about this motel business. There was plenty of objective evidence to indicate that she was serious about starting that business. Now, we saw on those facts the High Court held it is possible that she can get a deduction, but the court, a majority of the court, remitted it back to the tribunal for them to just make sure that there was enough of an intention there to start the motel business. I think probably you can already conclude there is. Now, so we see that, interest it is really one of the most common types of deductions in business, and it would be, it's a really important deduction in the sense that usually it's of a large magnitude interest. I mean, in the steel case itself, the interest bill was huge. It was worth fighting about in court. Now, so that's the general principle, right? So if funds are used, if funds are borrowed to buy an asset, to purchase an asset that is used for income generation, the general rule is you can get the interest as a tax deduction. Now, we'll specifically mention something that has been, topical in Australia. It's sort of always topical in Australia. That is the concept of negative gearing. So, does anyone know what negative gearing is? It's very common for purchasers of residential investment properties to engage in negative gearing, right? For landlords to do this. Anyone heard of it? Maybe you've heard of it, but not sure what it is. Anyone heard of it? Don't worry, I'm not going to ask you unless you want to tell me. But has anyone heard of this phrase, negative gearing? Yeah. Yep, Kim has heard of it. Yeah. So what we mean by negative gearing is this, that the interest expense on the loan plus any other expenses, right? But usually it's sufficient just to even focus on the interest, right? Because that's the major expense. So just think of this situation. The interest expense on the loan, which you have used to buy, say, a house or a flat to rent out, right, as an investment, the interest expense is actually greater than the rent, right? The interest, think about that, the interest is more than the income from the property. That's negative gearing. So you might think, why do people do that? Well, they do that all the time. Well, from an economic point of view, they're hoping that at the end of the day, they're still going to be better off because this property is going to increase in terms of its capital value, right? And in this situation of negative gearing, there is a tax benefit that exists in the law. It's existed for a long time. It's controversial. It arises as a political issue from time to time where, one political party, we've got it because of the particular election result we had, but sometimes it can be the opposition. It was the current opposition. In the lead up to the election was really going to reduce the scope for negative gearing, right? Because it is a controversial policy. Now, in this sense, right, this is the tax benefit that exists in the law. Now, remember, we are dealing with the situation where interest is greater than rent, right? Interest is greater than rent. That excess interest, right, you can use that as a tax deduction against your other income, right? It's still fully deductible. So lots of Australians are in this position where, what they do in terms of their profession, they could be, your lecturers might be in this position, could be professionals, right? Where mainly what they do is they're a professional or they're a lecturer, but they also have an investment property, right? And with the investment property, the interest is more than the rent on the property. Can they fully deduct that interest? Yes. Because even after the rent has been exhausted, the excess interest is claimed as a deduction against their salary, right? So it's fully deductible. That is, we won't go into it, but it has been controversial in Australia, the ability to do that. Okay, so that's what that is. Now, let's go to another category of expense here, legal expenses. Now, to some extent, we've done this already because we looked at cases like, we looked at Day, Snowden, Herald and Weekly Times, and in that context, we discussed how legal expenses associated with actual or alleged wrongdoing are deductible, right? All those cases, they were deductible. Now we're going to look at another aspect of this. Sometimes the legal expenses, they may look like they're related to assessable income. They may look like they're related to a business. But in some cases, the problem has been, the obstacle to deductibility has been that the court considers that the legal expense is of a capital nature and therefore not deductible. Right. So that was the holding in the Broken Hill case. Now, these cases are in your book around page 456. Now, Holstrom's case, you can argue that it's capital even in that case. And in fact, Justice Dixon, who dissented in that case, thought it was capital, but a majority of the court held it was on the revenue account and deductible. But actually, these days, the analysis is we think Justice Dixon was right, and we think it's capital even in Holstrom's case. So what happened in those couple of cases? What's the scenario? In what scenario can legal expenses be of a capital nature? Well, let's have a look at Broken Hill first, because in that case the court did hold its capital and therefore not deductible. You had the taxpayer was the sole operator of a cinema in Broken Hill, and the taxpayer incurred expenses and legal expenses in blocking a potential competitor's application to set up another cinema in Broken Hill, right? So here we have the taxpayer incurring expenses, legal expenses, to protect its business, to strengthen its business. It's really like the Sun newspaper's case, where we concluded that's capital expense and it's not deductible. It's the same kind of situation. It's expenses where you're trying to block and stop the competition. That's about preserving and strengthening your business and your market share, and that's going to be capital. So that's Broken Hill. Holstrom's case, I think it's capital too. Even though, in terms of the actual result, a majority of the court held it's on the revenue account and it's deductible. But as I said, these days we think Justice Dixon, the dissenting judge, is right. Now, what you had in Holstrom's, it's really a similar situation to Broken Hill. You had in Holstrom's a manufacturer of fridges, incurred legal expenses in successfully blocking a competitor's patent application, right? If you're blocking a competitor, it's the same situation. It's about strengthening your own business. Capital expense, I would argue, not deductible. Okay, I think that's what we now think about that case. Okay, capital in both cases. Right. Now, if we go to FCT and consolidated fertilizers, it is a different kind of context, okay? In this case, the court held it's deductible, legal expenses which are deductible. It's not the easiest case to understand, but I think it is right, but we just have to appreciate the facts. Now, here you had a manufacturer of pesticides and fertilizers. That's the taxpayer. They obtained a license from a US company to sell products which incorporated a particular kind of technology. Now, the developer of that technology brought a legal action against the US company, right, from whom the taxpayer had obtained the license, and then the taxpayer decided to join in that defense of the US company. And basically what the taxpayer is doing is that the taxpayer is incurring legal expense in order to maintain its ability to use a particular technology in its business that it needs to operate. Now, what the court held here and the view it took of the facts is, well, look, just to operate in business, this isn't even about increasing market share or really strengthening the business. Just to operate the business you do, that you have, you need to use this technology. And look, given this legal action now, you need to defend your right to use the technology. And how the court characterized this is that this is an expense that you need to incur in the prudent management of the business. Just to survive day to day as a business, you need to defend your right to use this technology. It's a management operational expense, and on that basis, deductible. So you can have a look at 457 to 458. It is not the easiest case, not that easy to reconcile that with expenditure that's considered capital. Right. Now, let us go to, how much time have we got? Repairs. So, I think, look, I'll say a few words about this, but we'll have to sort of close because we've only got a few minutes, right? So with repairs, we're looking at a specific deduction provision. It's Section 2510 of the 97 Act. And basically, this is an expenditure where if 2510 didn't exist, we would be able to claim it under Division 8. But it does exist, so we use this. So it's a deduction, it's a specific deduction, and this arises, it's in relation to property, assets that generate income, right? If you are trying to claim a repair as a tax deduction, it's got to be the case that still you need, for the purpose of this provision, a connection with assessable income. So the context could be you're a landlord, right? So you've got an income generating property, you need to fix something, you need to fix a leak in the roof, or you need to fix a hole in the ground. So that's what we're talking about. So yes, you can get a deduction for a repair, provided we are talking about a repair. What is a repair? A repair means remedying a defect, fixing a problem, right? So example, fixing leaks, rebuilding a wall, right? That's a repair. If we're talking about simply making something much better, that's not a repair. Now, the main issue that arises with repairs and whether you can claim a deduction is it capital in nature, right? Or is it a repair? If it's capital in nature, you can't claim it as a deduction all in one go, but it is an expenditure that it increases the capital value of the property, and you can get some tax relief over time.